Question is that the bill be now read a second time. Mr. Souza.
Sir, intellectual property is particularly important for Singapore as we continue to look for smart solutions and invest heavily in research and development. By monetizing intangible innovations, there is incentive to work on ideas and make them reality. This benefits society. The substantive law governing and protecting intellectual property is a key ingredient in ensuring Singapore's reputation as an intellectual property hub grows. This bill strengthens that framework so that IP rights can be better protected in Singapore. First, this bill introduces third-party observation and re-examination after grant process. Before I go further, sir, I should declare that I am a practicing lawyer whose practice also includes IP and acted in the case that appeared in the explanatory statement of this bill. Sir, the third-party observation process in Clause 10, the new Section 32 of the Patents Act, is available before the patent is granted. This would allow the patent granted to more accurately reflect the scope that would be adequate both for the rights of the proprietor as well as other innovators in the same field. Would the Minister elaborate on how this process may affect the turnover time for patent registration in Singapore? The re-examination after grant process is found in Clause 11, new Section 38A of the Patents Act. This new process supplements the current procedure. Although the applicant has less control in the ex parte proceeding, the applicant does not need to spend as much financial resources and time to challenge the patent. Even as it is good to provide this alternative process of challenging a patent, would the Minister elaborate on the safeguards to prevent a proprietor of a legitimate patent from getting deluged by these applications? Although the applications may not cost as much for the applicant as a court proceeding, these applications take a toll on the proprietor by increasing uncertainty. One or both of these kinds of third-party processes are present in other jurisdictions and regions such as Japan, Great Britain, Europe, Australia, and China. Having it in Singapore will further our position as an intellectual property hub. These processes make patents in Singapore more robust and accurate as there are more avenues to subject them to scrutiny. It is because it is ex parte, these processes are less costly and less time-consuming, something especially important for SMEs with limited resources and manpower, which is a point I think the SMS alluded to in his speech earlier on. In relation to the re-examination after grant process, there is a bar in the new Section 38A(5) of the Patents Act against the filing of an application where there is a pending court proceeding in which the validity of the patent may be put in issue. Would the Minister explain why there is no similar bar in the context of an ongoing arbitration, especially if a party to the arbitration is trying to get a second bite at the cherry by filing an application? Even though arbitration proceedings are private, the proprietary holder could possibly apply for a stay of the re-examination application. Second, this bill streamlines dispute resolutions by consolidating the jurisdiction for intellectual property disputes within the High Court. Currently, certain intellectual property disputes may be carried out at IPOS or at the various levels of courts. For example, copyright proceedings used to be held in a court, but has been changed in clauses 3 and 4 to only the High Court. The jurisdiction of the registrar at IPOS to determine infringement of a patent is removed by Clause 13. In this way, this bill consolidates intellectual property proceedings in the High Court, simplifying and streamlining the process. This may also assist in enforcement overseas, as cross-border intellectual property disputes may become increasingly common in an interconnected world. Overseas enforcement is particularly important for intellectual property disputes. However, along with this change comes concerns regarding costs. Small businesses already tend to avoid enforcing intellectual property rights due to somewhat prohibitive costs and a potential war of attrition. While the bill provides for indemnity costs under certain conditions at Clause 6, this is only for geographical indications, and a trial and hearing at the High Court still costs significantly more than that of a lower court. Furthermore, as some of the procedures were previously carried out by IPOS, what will be done to ensure that our judiciary has the necessary expertise and resources needed to replace that function? Third, this bill makes it clear that disputes relating to intellectual property rights are arbitrable. This is important, as there is some school of thought that certain intellectual property disputes, such as copyright and registration of trademark or patents, are non-arbitrable, as it is against public policy. These are some arguments, not necessarily arguments I would agree with. For example, the review of the Arbitration Act Committee's 2000 report, Review of Arbitration Laws, espoused such a view. However, the position in the bill is not novel. It is a position that is also made clear in Hong Kong by the Arbitration Ordinance Act, which came into effect 1st January 2018. There are advantages to having intellectual property being arbitrable. Firstly, the confidentiality of arbitration proceedings is especially relevant in intellectual property cases, where the very thing that is being disputed is an intangible and sometimes, and quite often, a confidential asset. Secondly, a total of 160 states have signed up to the New York Convention on the recognition and enforcement of foreign arbitral awards. Thirdly, parties have greater control over whether they desire to have a matter arbitrated, for example, in a neutral jurisdiction instead of the place of business. While the new Section 52C3 of the Arbitration Act and 26C3 of the International Arbitration Act make it clear that an arbitration award involving intellectual property rights does not affect the third-party holder of a security interest, could the Minister elaborate on how this will operate? This bill sets out exciting changes to the intellectual property dispute resolution landscape. What will be done to strengthen and train up capabilities of our people so that people in our legal industry can benefit from these changes? This includes arbitrators specializing in IP, legal practitioners in the field of intellectual property and disputes, and thought leaders in arbitration, dispute resolution, and intellectual property. There is much potential in this bill. People who develop and own intellectual property, software engineers, designers, small, medium enterprises, for instance. People who use technology in their day-to-day life will also benefit from this bill. Why? Because intellectual property rights are supported through a more robust dispute resolution structure. And for those reasons, I support this bill.